So equivocal death investigations. Now, here's the deal with that. Equivocal death investigations are what are also termed as possible staged crime scenes. In other words, was it made to look like an accidental death or a suicide or a natural death, etc.? So it's an inquiry that's, quote, open to interpretation. Now, the question here is, should you as a homicide investigator approach every death scene as equivocal? Yes, you should. You should not take it for granted that what you see or what you believe occurred actually occurred. One of the problems that detectives or any investigator has, and it's not just with homicide investigations, it's any investigation, is having a suspect in mind and making the suspect fit the facts and circumstances. And we'll get into this in a second. But it's important for every investigator to begin with the end in mind. And when I teach new agents this in their basic agent class, we talk a lot about being on the hot seat, being on that witness stand. And I can tell you, having been on the witness stand many, many times throughout my career, it is a lonely place. You are out there on an island unto yourself, and you're staring. You're staring at the jury. You're staring at the public. You're staring at the defendant. You're staring at the prosecutor. You have no friends up there. You are on your own. And it's important that when you are sitting in that hot seat, and I always go back to my favorite quote by Mark Twain, when you tell the truth, you don't have to remember anything. So tell the truth, but also let the facts stand on their own. They're not, as an investigator, facts should not be subject to your interpretation on the stand. Facts will lead you in certain directions. And as long as you go in that direction and be logical about it, just let the facts speak for themselves, right? Now, your author talks about how you only get one chance at this. Do it right the first time. And it's very important that you do it right the first time. Investigators that have other things going on in their lives that, break them away from what they're supposed to be doing, well, it all will come to a head here in the jury box for sure. So you have to begin with the end in mind. Now, an equivocal death investigation, you don't know. Is it a suicide? Or are you going to charge someone with murder? Because in an equivocal death investigation, there are facts and circumstances that will lead one to think that this was in fact a suicide, a natural death, an accident. But you are charging someone with a crime because you believe, and the prosecution believes, that the facts and circumstances support the charge of manslaughter, murder, etc. Okay, homicide, support a homicide. So begin with that end in mind and make sure that you are not making the facts fit your version of the events, that the facts stand on their own. So your book gives you case studies on equivocal death investigations. You will see how these sort of set up and sort of interesting, but it is, not uncommon for a crime scene to be staged. This is a recent case that is up here in Fort Collins that I think is a good example of an investigator getting tunnel vision and making the facts fit a suspect. And this is the prosecution of Tim Masters. Some of you may be more intimately familiar with this, but Peggy Hetrick was a woman found murdered in a field up in Fort Collins, and Tim Masters had a house. He was a young kid. He lived very close to there, and really through a neighborhood canvass, investigators, including Lieutenant Broderick, who was a detective at the time, really felt that Masters was their guy. And the investigation then focused completely on Masters, and all of the facts and circumstances that were built, and very circumstantial, sort of relied on, that was our man. This was the guy that we believe did it. And he was ultimately prosecuted, convicted, and then later exonerated. And Broderick was indicted twice by grand juries for perjury charges. It ended his career effectively. It also sort of ended a prosecutor's career. So you have to begin with that end in mind. And certainly what we don't want to do, you do not get into this, and I can't imagine having this on one's conscience, where you really feel like you're not sure that you put someone in prison. I've heard, maybe, yeah, we got the guy. He definitely did it. You sort of convince yourself that you have the right person, that your interpretation of the facts is correct. So I can't imagine having that on your conscience. I can't tell you how many times in my career I have heard new investigators say, we know we did it, we just can't prove it. We know we did it, we just can't prove it. Well, if you can't prove it, then you better not be, charging someone with a crime. And so I think this is a good example of what could go horribly wrong. And we've talked about exonerations. We've talked about each year there are a number of exonerations nationally that occur because of perhaps overzealous prosecution, messy investigations. Juries want to believe the prosecution. I have, on voir dire, sitting there, I have heard potential jurors say, look, if that guy's sitting there, he's guilty. People believe that. Even to this day, they still do. So just, be wary of the power that you yield as an investigator, as part of the prosecution team. All right, so PowerPoint, there we go. Oh, there we go. All right, so getting into equivocal death investigations, I want to touch on what it takes to charge a crime and just generally the steps of charging a crime. Now, hopefully you've got this in your Intro to Criminal Justice classes, but I want to reinforce this. What are the steps that an investigator has to go through to charge someone with a crime? So in the state of Colorado, now federal and state sort of track each other. There are different nuances between charging someone federally and charging someone with a state crime, but generally murder, homicide investigations are state crimes. It's rare to have someone charged federally or on federal property, etc. So most murders are charged at the state level. So an investigator, generally the way this works is that an investigator gathers the evidence and they work with a prosecutor, a deputy district attorney, and they decide, and really it's the prosecutor's decision, that the facts lead to beyond a reasonable doubt, that they're ready to make an arrest. Now, sometimes you have to make an arrest just upon that standard of probable cause and then sort of build your case after. That's not the way to go about it. Generally, before you even charge someone, you want to have your ducks in a row and want to be able to prove your case beyond a reasonable doubt. But sometimes public safety issues, other circumstances, that you make an arrest on probable cause. And sometimes, arrests are made based upon probable cause, but they just don't have enough to really, really go forward with a trial. And so they'll sort of roll the dice, make an arrest and try to get an interrogation in to get a confession. So when you're charging a crime, generally a detective or an investigator, detective is generally used, at least in Colorado here, by police departments, and then investigators generally used by sheriff's departments, just sort of a nuance on a title. But they'll charge a criminal complaint. So they will write an affidavit, telling the judge why they want to arrest this person. Now, a criminal complaint has to be filed in the state of Colorado. Now, a detective can arrest without a warrant, so they can just go pick someone up and arrest them. And then ultimately they'll have to file a complaint. Or you can file the complaint first, get the arrest warrant, and then go effect the arrest. So generally that's an affidavit by the detective, by the lead investigator, giving the judge probable cause for the arrest. Another way to charge someone is through an indictment. Now, you hear about this quite a bit. States generally don't use grand juries to seek indictments the way feds do. Feds indict every case, and in fact, you have a constitutional right to an indictment under the Bill of Rights. But again, we understand that not all rights that are enumerated in the Bill of Rights are put onto the states. This is the notion I think we've talked about in this class, that there's a selective incorporation, that certain rights are incorporated to the states by Supreme Court precedent, and the right to a grand jury indictment has not been one of them. So on the federal level, everybody's indicted. On the state level, most people are not indicted. But sometimes states use grand juries, particularly in very large investigations. Remember the JonBenet Ramsey case? There was a grand jury that was impaneled. A grand jury are just, people that got the notice in the mail saying, I got to go to jury duty, and then they show up and they're like, wait a minute, this is a grand jury. This is impaneled for a long time. It's not just one trial. It could be several months that you're on a grand jury. So in a grand jury, investigators come in. It's run by the prosecution. An investigator or witnesses come in and they tell the grand jury, the case. They lay the case out. And the grand jury decides if there's probable cause, right? The grand jury decides if there's probable cause. Another way to bring someone in is called an information. And this is generally where, say, the detective has reached out to the suspect's cooperating, she's obtained an attorney, and they've already sort of worked out a plea deal in advance, or they're sort of cooperating. Generally, because of that cooperation, you'll have an information where the arrestee just sort of appears in court. In other words, there's no sort of, actual arrest where the detective or police officer goes out and arrests someone. They just tell them, hey, show up in court. They'll book them, they get booked and everything, but then they just kind of show up for their initial appearance at that same time. So regardless of how the person is brought in, now also once an indictment is handed down by a grand jury, an arrest warrant is issued after that. So regardless, in a criminal complaint, an arrest warrant is issued, an indictment, an arrest warrant is issued after they return an indictment, and then an information is more of a notice to appear. So generally the first step is an initial appearance. And so when someone's brought in front of a judge, and generally there's a requirement that within 72 hours after arrest, a person has to be brought before a judge where they're read the charges against them and bail is set at that. And then if there's custody, like for instance, bail, that's the hearing to determine whether or not a person's going to be eligible for release under bail or going to be held pretrial detention because of a threat of flight or a threat to the public safety. So, and they're also read their rights at that point. Now, here's an interesting nuance. So a preliminary hearing is held to determine probable cause. Now, this in the state system is like a mini trial. So a prelim is where a witness, not all witnesses get up. Generally, it's the lead investigator will get up and will detail probable cause. It's just a finding of probable cause by the magistrate. If someone's indicted by a grand jury, you don't need that hearing. That hearing doesn't occur. But generally, you'll have a preliminary hearing to determine whether or not there's sufficient cause, probable cause to make an arrest. Again, at the federal level, because everybody's indicted, you don't generally have prelims. But in the state level, we generally do have preliminary hearings. So once the magistrate or the judge finds that there is probable cause after a preliminary hearing, the person's arraigned on the charges, a formal arraignment occurs, and that's just where they're read formally their charges based upon the finding of probable cause. Okay, at that point, then a trial is set, and at that point you have motions, prosecutorial defense motions, etc. But an important part of marching towards trial is discovery. Oh, but before I get into that, let's talk real quick about the public defender. So both in the state and federal system, if you are charged with a crime where you could be imprisoned, right, where you could go to jail, you have the right to a public defender. Now, this is a Sixth Amendment right. Again, under the notion of selective incorporation, under Gideon versus Wainwright, Supreme Court said, look at, it's fundamental. Defendants will have right to counsel in the state system as well. So you always had it in the federal system, but the state system under Gideon versus Wainwright. And in 1963, the Colorado Defender Act was passed that gives those accused of felonies or misdemeanors where there is the threat of incarceration, the right to a public defender. They can't otherwise afford it. So again, we're marching towards trial. Now, this is important, and it gets into equivocal death investigations. Discovery. Discovery is that part where the prosecution gives over their evidence to the defense. Now, let me tell you something. I don't know where this gets messed. I think this gets messed up in the rules of criminal procedure, but there are rules for discovery. And although there are rules for discovery, I can tell you right now that most prosecutors and investigators get in trouble because they fail to disclose everything that's part of their investigation, okay? Now, you absolutely have to turn over what is deemed exculpatory evidence, but what's exculpatory is subject to interpretation, right? So generally, there are rules. You have to give over reports or witness statements before a witness testifies, and you have to give over certain evidence. But again, this is where investigators get in trouble, and particularly in an equivocal death investigation, where, for instance, the defense is saying, wait a minute, not guilty, this guy committed suicide, and the prosecution is saying guilty, this guy killed this person and made it look like a suicide. So it's important as an investigator, you represent the people, right? You represent the public. And in our democracy, we have to have government that's transparent. This is the only way for our democracy to work. And you as an investigator are a huge representative of that government. And in fact, you're the part of the government that can put someone in prison. So it's always been sort of important to me, or it's been impressed upon me, that when you conduct an investigation, don't hide your cards. You got to put them out there. And that's what this process of discovery is. Discovery, as it says here, it prevents trial by ambush, where the prosecution is not transparent, where the defense doesn't know, that a witness is going to testify or certain evidence is going to be produced. Discovery is more important for a prosecution, to the prosecution team, to give over everything they have. It's very, very important. And we see that in the Tim Masters case too, where not everything was handed over. The defendant has to be able to put on a valid defense. And again, it's the prosecution's job to prove beyond a reasonable doubt. Now look, I have been blindsided in trials that I've been in where witnesses have showed up last minute, where things, and I can tell you right now, the defense gets a lot more leeway with discovery than the prosecution does. But it's very important that that investigators work with their prosecutor to try to get absolutely everything over that they can. Ultimately, it's the prosecutor's call what gets turned over, but I can tell you, I push my prosecutors, just turn it over. What's the big deal? Just turn it over. Yeah, it could muddy things up. So what? You know what? It is what it is. It's a fact. So it's important to understand that part of discovery.